So this is the agenda for this morning. So key data protection developments over the past year is what I'll start by talking about. Now, because of time constraints, this is very much going to be a whistle-stop tour of some of the latest developments, kind of a taster and a teaser, if you were. At the end of today's session, we're actually going to do a poll where you can vote for maybe the topics or topic that you're particularly interested in hearing about further, and we can always cover things off in more detail in a later session. But today is very much kind of a taster, kind of the movie trailer, as you were, of the full length feature. So just to give you a taster of what we can talk about, really. Then next, Andrew will then move on to talk about international transfers. It's a really interesting area of law at the moment, post-Brexit. And then the future for data protection law as well. So you may know that the government is thinking about reforming data protection law, and there was a consultation at the end of last year, which Andrew will talk you through as well. So fascinating time at the moment to be a data protection lawyer. And then I will wrap up things this morning with just a short session on what to focus on now, so what your priorities should be, that kind of thing. I thought I'd start off by talking about enforcement action and court decisions, so kind of the hard end, as it were, of data protection compliance, where things go wrong, really. So I'll start by talking about some information security cases. And I wanted to start by talking about the Cabinet Office fine, actually. You might remember, if you can cast your minds back pre-pandemic to December 2019, the Cabinet Office mistakenly published the New Year's Honours list online, but they made the mistake of publishing the list alongside the postal addresses of the people who had been awarded the gongs that particular year. And it's taken a couple of years, but the ICO, towards the end of last year, issued the Cabinet Office with a fine of £500,000 for that particular breach. Originally, apparently, it was going to be 600,000, but the Cabinet Office managed to persuade them to bring it down to £500,000. So still a substantial fine, even for an organisation as large as the Cabinet Office. And there are some really interesting takeaways, I think, which is why I wanted to talk about this particular case. So it goes to show the importance of testing. So one of the things that had kind of gone wrong in the situation is that this new IT system was implemented without sufficient testing and without sufficient kind of training in place for staff members as well. And so the ICO focused on a variety of things that they thought the Cabinet Office could have done better to prevent this from happening. I think there are takeaways for all organisations around these things, and we see them at BWV time and time again. You know, staff training is just so essential. They were also criticised by the ICO for lack of having a sign-off procedure for publishing things online. So if your organisation publishes things, personal data in particular, on your website, for example, think about what procedures you have in place there to prevent what happened in the Cabinet Office situation essentially going wrong and too much personal data being processed. So what sign-off procedures have you got in place there? The second thing I wanted to talk about was a fine given by the ICO to an HIV charity in Scotland. This fine was smaller. It was only, I say only, it was £10,000, but you can imagine for a smaller organisation, that is still a large amount of money. And what had gone wrong with this HIV charity, they had sent out their newsletter to their subscribers, but they hadn't hidden the recipients' email addresses. So whoever received this particular email also saw the email addresses of everybody else. And because of the sensitivity of the charity, the work they do around HIV, that was potentially revealing health data or special category data, as we would call it in data protection terms, about the other recipients as well. So this is a really interesting case because it's something we see quite a lot when clients come to us for help with data breaches. It's this idea about things going wrong with an email, so not using blind copy, for example, where it should be used. What was really interesting about this ICO case is that the ICO said that actually relying on staff members to remember to use blind copy rather than CC or 2 wasn't good enough. And actually, they should have had better procedures in place when sending out their newsletter because it's just too prone to human error. So that was really interesting. So if your organisation do send out things like newsletters to a large number of people, think about what procedures you've got in place. There are different software applications that will do it for you securely rather than having to rely on staff members. And the second kind of limb of enforcement action, so almost the second most common reason, as it were, for ICO enforcement action is marketing. It's breach of the privacy and electronic communication regulations. So if you are someone that's responsible for marketing at your organisation, do have a think about your compliance in this area. There's one particular case that was relatively recent that I wanted to flag in particular, which is the fine given to an organisation called Temp Cover. And this is a really interesting case around what's called the soft opt-in. So broadly speaking, before sending email marketing, direct marketing by text or emails, you have to get the individual's consent. There is an exception to that known as the soft opt-in, which is where you have obtained the contact details during the course of a sale or negotiations for sale, but you have to have given the individual, when you obtain their contact details, an easy method of opting out. And that was what Temp Cover hadn't done properly. So just to flag this issue around PECA, as we call it, the Privacy and Electronic Communication Regulations, it is something where the ICO are increasingly doing enforcement action. Last week, actually, they've published a variety of different enforcement action they've taken about live telephone calls. I won't go into as much detail about those particular actions because they were really unscrupulous companies targeting vulnerable individuals, elderly individuals. But I thought that Temp Cover case in particular was more probably relevant to the life sciences sector. And then just very quickly, again, this is a bit of a whistle-stop tour. Notable court decisions, there's two in particular that I wanted to mention around compensation claims. So you may have heard that the Supreme Court heard a case last year, Lloyd Google, which was essentially about whether individuals could claim compensation for mere loss of control of their personal data. So the court helpfully decided, I say helpfully, it's helpfully for organisations more so than people wanting to claim compensation, held that mere loss of control, so a mere breach by itself, wasn't enough to be able to claim compensation. You actually needed to be able to demonstrate that the breach of data protection law, it didn't have to be a data breach, but a breach of data protection law, you have to be able to demonstrate that has caused you some distress or financial damage, something like that. A mere breach by itself, or loss of control, as it's generally called, that wasn't enough to be able to claim compensation. So that was really good news. And then the other case I wanted to mention is actually a case that BWV were not just involved in, but it was a case against us. So we had a data breach, as most organisations will do from time to time. It's a very low level data breach. Essentially an email was sent to the wrong email address. It was simply a typo in the email address. And we actually managed to get this case struck out. And that was obviously great news for us, but also great news for a lot of organisations who, all organisations from time to time suffer from data breaches. But the great news about this one was just how vigorous, for want of a better way of putting it, the court were in striking out this particular claim. And I'm just going to find now just one kind of quote from the judgment by the judge in this particular case. So remember, this was simply an email typo. It was a really kind of common data breach. And the judge in our case struck out the claim and said that there was no, I'm quoting now, no credible case that distress or damage over a de minimis threshold will be proved, which is why it was struck out. In the modern world, it is not appropriate for a party to claim, especially in the High Court, for breaches of this sort, which are frankly trivial. So that was great news, because we have seen a growth over the last few years in people claiming compensation for really trivial breaches. So hopefully the tide is now turning in organisations' favour. And it seems to be that actually people do need to be able to show some form of damage or distress in order to claim compensation. That was a real whistle-stop tour, though. If you want to hear about more of those types of things, do let us know, and we can also do another session on that type of thing. And then finally, on this slide, I just wanted to mention that the immigration exemption has now been reformed. So the immigration exemption in the Data Protection Act, which allows organisations to essentially not comply with various aspects of the GDPR if it would prejudice immigration control, that's now being reformed and can only now be relied on by the government. So if you were previously relying on the immigration exemption, just to flag, you will no longer be able to rely on that exemption. It can now only be relied on by the government. And then I wanted to kind of cover off a kind of a highlights reel of ICO guidance that I think is particularly relevant to the life sciences sector. I picked 5. I ummed and ahed for a bit about which 5 to pick, because there were others that I had to leave off the list. But as I said, if there are areas that you're interested in hearing more about, we are doing a poll at the end. So I'll just very quickly explain these 5 pieces of ICO guidance, just give you a taster. So the data sharing code of practice is one of the statutory pieces of guidance that the ICO is legally obliged to produce. It's statutory guidance as opposed to their normal guidance. So it has more of a sway, and the courts actually have to take it into account when considering data protection compliance. So the data sharing code of practice essentially outlines the ICO's expectations on how to comply with the law around data sharing. Now it carves out data sharing with a processor. So the code of practice is simply about sharing where controller to controller. For those of you not particularly familiar with data protection law, controllers are the organizations that decide the manner and means of personal data being used. So they're the organizations that essentially determine the how and the why of why personal data is being used. And then processors essentially use personal data on behalf of a controller in accordance with their instructions. So this code of practice is on controller to controller sharing, not processor sharing. Some of the key points from this code of practice include the fact that the ICO are very clear that before sharing personal data, you should get very clear on what your objective is, because once you've identified your objective, it's so much easier to work out how to comply with the other data protection requirements. I'll just go over a few of those requirements very quickly. So obviously before sharing any personal data, you need to identify a lawful basis to do so. If it's special category data, you have to come up with a condition as well. Now, there's something called the data minimization principle, which is very relevant to data sharing as well, which is that you should only be, in the context of data sharing, only sharing the minimum amount of personal data necessary to fulfill your objective. So that's why it's so important to get very clear on what your objective is at the outset, because everything else kind of hangs from that objective. Other things to think about: how are you being transparent with the data subjects, the people whose data you're sharing? Think about security as well. That's just a flavor, as it were, just to kind of flag that data sharing is quite a big topic. So if you'd like us to do another webinar solely on data sharing, do let us know in the poll later. And then very relevant to the life sciences sector, the ICO about a month ago now published some draft guidance on the research provisions of the UK GDPR and the Data Protection Act 2018. Now, that might be because the government's reforms focus quite a lot on reforming the research provisions. So I think the ICO probably felt it was possibly, as my speculation, time to kind of clarify the current law in this area. So they've released some really useful pragmatic guidance on the research provisions. It is out for consultation, and that consultation is open until the 22nd of April. So you've still got time to have your say if you haven't had a chance to look at it yet. I think the guidance is actually really helpful in explaining quite a complicated area of law, because the research provisions are scattered all over the GDPR and Data Protection Act. So the guidance kind of brings them all together in quite a useful way. So if you haven't read that yet, I would recommend having a look at that. It can be found on the ICO website quite easily. And as I said, the consultation is still open, so you can still have your say. And then the accountability framework is the next thing I wanted to flag. So accountability is an absolute keystone, cornerstone of data protection compliance. It was one of the big changes that came in when the GDPR came in. It's one of the main things that distinguishes the old law, Data Protection Act 1998, from the UK GDPR. So accountability essentially means you have to be able to demonstrate your compliance. It's no longer enough simply to comply with the law, you have to be able to demonstrate that compliance. So the ICO's accountability framework is really helpful in setting out the ICO's suggestions of how you can comply with this requirement and their kind of expectations. Now, the really important thing to flag about the accountability framework is that it's not prescriptive in any way. It very much is just the ICO saying, well, this is one way you could comply, because the ICO are absolutely stressing in this framework that there is no kind of tick box way of doing accountability. It's very much risk-based and will vary from organization to organization. And then ransomware is the next thing on the list. I'm going to be talking about that a bit later this morning, so I'm just going to quiz over that very quickly now and move on quickly to anonymization and pseudonymization. So quite relevant, I would imagine, to any research work the life sciences sector is doing. Anonymization is a really important concept in data protection law, because if something is anonymous, data protection law doesn't apply to it. So it's really important to be able to work out if something is personal data or if it's anonymous. Now, personal data, just as a bit of a refresher, is data that relates to an individual, a living individual, from which that individual can be identified. So you look at the data itself and you say, oh, that's about Claire Hall, that's obviously about Claire Hall. Or you're identifiable from it. So I may not be identifiable from the data itself, but combined with other things, I'm then identifiable from that data. Now, anonymization is really kind of quite a complex thing, because the question is, well, how far do you have to go to make something anonymous? And the key point in the anonymization guidance, which is in draft form still, just a flag, one of the key points in it is that you don't have to make something absolutely impossible to identify someone from for it to be anonymous. The ICO are talking about effective anonymization as being enough to mean data protection law doesn't apply. So a really important key concept there. And I've realized I've spoken for quite a long time. So I'm now going to pass over to Andrew, who's going to talk about international transfers.
Thank you, Claire. So yeah, I'm going to talk about some new developments around international transfers of personal data. And I'm then going to look on just more broadly at the government's proposed reforms to data protection law and what they might mean in practice. So the topic of international transfers has attracted quite a lot of interest and scrutiny. There are people who are concerned about their data being sort of sent overseas without knowing what's going on. There are concerns about sort of other countries not having the same sort of level of protection. It can be a pretty complex area, and it's possible to easily get lost and sort of go down a rabbit hole. So with that in mind, I just want to start off just with a brief reminder about what the key principles are. So in essence, you can only transfer personal data outside of the UK in the majority of cases if one of three conditions are met. The first condition is that the destination country has an adequacy finding from the UK government. Essentially, this means that the country is on the UK safe list of countries that the data can be transferred to. So that includes, for example, the EU member states and some other countries such as Israel and South Korea. If the destination country isn't on the safe list, then you can make the transfer so long as there is a safeguard in place. And the safeguard that will be applicable in the vast majority of cases are what's known as standard contractual clauses. Essentially, these are government-approved clauses that you can incorporate into your contracts or have as a standalone contract that contain contractual provisions that help make the transfer lawful. And we're going to talk about these a bit more in a moment. So if there's no adequacy finding and there's no safeguard in place, then as an absolute last resort, there are some limited exceptions that mean that the transfer can take place. But these are very limited. For example, if you had an employee who was in Brazil, say, and they suffered an accident and you needed to transfer their data to a hospital there, then that would be permitted in that sort of situation. And equally, if you need to transfer personal data to bring a claim, for example, against an overseas partner. But for the most part, when you're thinking about transferring personal data, you'll either be relying on an adequacy decision or relying on standard contractual clauses to incorporate into your contracts with your partners. So the current versions of the standard contractual clauses are really old. The most recent one is twice as old as the GDPR. So change is long overdue, and that change has come in the form of what the ICO has called its International Data Transfer Agreement, or IDTA. So these are new standard clauses that will be needed, that you'll need to use as your safeguard. And the IDTA comes into force today. So this means that going forward, you should be thinking about using the IDTA. Having said that, though, there is quite a long grace period, so you can continue to use the old SCCs until 21st of September for existing transfers, and then for any contracts that were entered into prior to 21st of December, they continue to be valid until 21st of March 2024. So there is quite a long grace period. So is the new IDTA any good? Is it worth using, or should you just carry on with the old SCCs for the time being? So in some respects, the ICO's new IDTA is good. It uses far less legal jargon, so there's lots of plain English. It's easy to follow. There are also a lot more prompts. So when you complete it, for example, it's a prompt to spell out the specific security measures in place to protect personal data, which I think is useful. This encourages you to make sure that the transfer complies with the wider requirements around GDPR compliance. Now, the EU have produced their own version of the standard contractual clauses. So imagine you're in a situation where you are sharing personal data with one of your officers in France, and then you also need to share the personal data with, say, a partner in the United States. A risk is that you'd have to enter into both the EU and the UK standard clauses to make the transfer lawful. But happily, that's not the case. And this is because the ICO have also produced a bolt-on. That means that when the transfer has an EU element, you can use the EU version of the clauses plus the ICO bolt-on to transfer data overseas, over countries such as America, without actually having to sort of have two full versions of the standard contractual clauses. So in some respects then, the IDTA is a real step forward, but equally it's not all good. As you might imagine, it's quite a lot more onerous. So there are a lot more compliance obligations in. There's also a provision that says if the ICO update the IDTA template, then the updated template will automatically apply to contracts already signed, which is, I think, an absolute killer. So you could suddenly find you signed up to one version of the contract, and then you're sort of required to comply with additional provisions in circumstances where you hadn't actually agreed to that. The other complexity is so if you're transferring personal data to a data processor and you're using standard contractual clauses, in addition, you've also got to make sure that the contract complies with the controller processor provisions in the GDPR. And these provisions mandate certain clauses that must be included in contracts, for example, around security, around helping with data subject requests, and so on. And what that means then is that there are essentially two sets of model clauses that you need to make sure are incorporated into your contracts if transferring personal data overseas to an overseas data processor. The further complexity is in as some of you may remember, in a couple of years ago, the privacy campaigner Max Schrems brought litigation concerning the lawfulness of transferring personal data to the United States, and the European courts found that simply relying on standard contractual clauses by itself wasn't sufficient, and instead it was you also needed to risk assess the transfer. So because that decision wasn't made whilst we were still subject to EU law, we are still bound by that decision, which means that you should be risk assessing the transfer and seeing whether you need to put extra measures in place to make it compliant, in addition to what's contained in the contractual paperwork. And perhaps slightly unhelpfully, the ICO hasn't yet finalised its guidance on the risk assessment process. So that's something to look out for. So in summary, therefore, if you're transferring personal data overseas and the destination country doesn't have adequacy, then you'll need to, in most cases, you'll need to rely on the standard contractual clauses, either the existing ones for the time being or the ICO's new IDTA. If the third party is a processor, you'll need the mandatory controller process provisions in place, and you also need to carry out the risk assessment. Okay, so I also want to talk about some recent developments in terms of the government's proposed reforms of data protection law. So last year, the government consulted on what people want to see changed in the GDPR and in the Data Protection Act, and essentially, as I put it on the slide, they're really sort of looking to promote a pro-growth and innovation-friendly data protection regime that sort of keeps pace with technology and that's agile and that sort of allows organizations to use personal data in a way that will sort of promote growth and innovation. I think in practice this probably means a slightly more light touch approach to compliance that perhaps doesn't quite give individuals the same protection as perhaps they have currently under the existing regime. And at the same time, the EU appear to be heading in the opposite direction, in the sense that they seem to be sort of building in additional protections for people that weren't necessarily explicit in GDPR. For example, recently the French and the Austrian equivalent of the ICO issued decisions that they both found that the use of Google Analytics was unlawful because Google transferred the data to the United States, and the safeguards that Google had put in place weren't sufficient for compliance. And this puts the UK in a really difficult position, because on the one hand, the government wants a data protection regime that's sort of more lean and agile and that promotes innovation, but at the same time, if we depart too far away from the EU model, then the EU may decide that we're no longer a safe country to transfer personal data to, and they could therefore restrict transfers in the future. Last year, the EU gave the UK the benefit of an adequacy decision, so which meant that from an EU perspective, the UK was a safe place to transfer personal data to, but they, perhaps anticipating the direction in which the UK would go, it included a sunset clause, so it will automatically expire in a few years' time, which means that the EU will then have another opportunity to assess whether the UK, in their view, still has adequate protection for personal data. Okay, so I just want to sort of finish off my bit then just by thinking about some of the proposed changes contained in the government consultation in the reform document. The first thing to note is that there's a real sort of drive towards reducing GDPR red tape. The government makes the point that the GDPR has a tendency towards sort of box ticking compliance. So there are, for example, lots of sort of overlapping documentation requirements that sort of take a lot of time and effort without actually necessarily making sort of personal data better protected in practice. For example, you've got something called the Article 30 record, the appropriate policy document, which many organisations will need. These are explicitly required in GDPR, but to be honest, it's not clear what value they have. In addition, the government is looking at doing away with the statutory DPO role. Organisations would still need to have somebody with data protection responsibility, but it would no longer need to be a data protection officer. And one of the problems organisations have faced is that who do you appoint as your DPO? Because the GDPR says they can't have any responsibilities that conflict with a data protection role, which has been interpreted to mean essentially that someone senior in the organisation couldn't be the DPO because that might put them into a conflict, a conflict situation. And we've seen clients, for example, appoint sort of quite junior people with no real experience in data protection as the DPO, simply because there was no one else that they could fit into the role. There's also going to be greater flexibility for using personal data for research purposes. As Claire mentioned, the research provisions are sort of scattered all around the Data Protection Act and the GDPR, so that anyone actually trying to understand what they can and can't do would sort of could well be at an absolute loss. So they're going to be consolidated. In addition, and perhaps surprisingly, there's no definition of scientific research in the GDPR. So again, it's not always clear to people, is what I'm doing falling within the research provisions. So the government plans to introduce a fairly broad an expansive definition of scientific research. Another thing the government's really keen on is AI, artificial intelligence. So using technology to make decisions that a few years ago would have to be reserved for human beings. Now, one of the safeguards in the legislation is that if a decision is made without sort of human intervention, then the individual is entitled to get a human to review the decision. So let's say, for example, you decide to write a computer program that would decide whether or not somebody is offered a job. That would, as things stand, if somebody wasn't offered a job, then they could challenge that. But potentially going forward, that will go away. So people wouldn't have an automatic right to challenge a decision that was made entirely by a computer. Okay, subject access requests. These are probably sort of the area of data protection compliance that gives many of our clients' biggest headaches. Essentially, for those of you are familiar with these, they give people a right to request a copy of their personal data, and also a right to certain other information as well. And they are often used in relation to complaints. So if you have an employee who's really unhappy, who's thinking of bringing a complaint, they might make an SAR to obtain their personal data, perhaps fishing for information that they feel might sort of assist with their complaint. And some organisations get absolutely inundated with these, and they take up so much time and resource to deal with them. And the government is alive to this and is thinking about reforming the right to make it a bit more refined. For example, to sort of restrict.
Andrew,
yes, Paul?
Sorry, the sound has just gone. It was fine until about 5 to 10 seconds ago. It's gone a bit muffled. Just on your speaker, we can hear you, but it's,
okay.
it's a bit.
Is that
better? That's
okay,
it.
right.
Thank you.
I'm not sure what happened. Thank you. I'll try and speak a bit closer to the microphone. Yeah, so I was just saying, subject access requests, they can be really problematic because they can take up a lot of time and resource to deal with. The government is planning to help organisations in two ways. First, by possibly putting what in effect would be a time limit on how long the organisation would have to spend on seeing where the information is held and extracting it. And second, by lowering the threshold before the organisation can refuse to deal with a request, by making it more sort of akin to the vexatious request regime under the freedom of information law. So if it's clear, for example, that somebody has no real interest in their personal data, they're simply trying to make an SAR for tactical reasons, even to sort of to fuel litigation, then there may be more scope to refuse to deal with the request. And then finally, the government's also very keen to reduce the barriers to international data transfers, for example, by being more proactive in terms of offering countries adequacy. There's a suggestion that America's going to get adequacy, which means we won't need to worry about standard clauses when transferring personal data to the states. So it's been interesting to see how that goes, and in particular, how that sort of fits in with our relationship with the EU, and to what extent the EU will sort of feel that we've gone too far, and maybe even decide that we are no longer a adequate country for data protection purposes. So lots happening, lots of uncertainty. But I think taken holistically, the government's consultation is a step forward, because it recognises some of the challenges that businesses face, and it seems to be sort of trying to streamline things while still sort of protecting people's rights and their data appropriately. Okay, so I'm going to hand back to Claire, who's going to finish off by looking at some of the key compliance things that you should be thinking about.
Brilliant. So what to focus on now? So I'm going to spend the last 5 minutes with some really kind of practical, hopefully, tips around what you should be focusing on now, based on all the things that Andrew and I have kind of seen and learned over the last kind of year. So the first thing I'd like to talk about is cybersecurity and how important cybersecurity is. Now, I imagine a lot of you on this call, and I've seen from the delegate list, a lot of you won't be IT experts, and I imagine your organization will have an IT team. It's certainly the case that they should be leading on your cybersecurity defenses, but please don't think that it's just for them. So data protection is something that should be considered by everybody in your organization that handles personal data. And I really want to focus today on ransomware. For those of you not familiar, ransomware is where, and I'm kind of broadly summarizing here, paraphrasing a little bit, but broadly speaking, ransomware is where an attacker gets access to your systems and encrypts some of your data and won't give you access to it, won't give you the key, as it were, the encryption key, unless you give them a sum of money, a ransom, essentially, often in Bitcoin. And now ransomware is considered by the National Cybersecurity Centre to be the biggest cyber threat facing the UK at the moment. And things are heightened at the moment because of the Russia-Ukraine situation as well. So cyber defences are really, really important for all organisations. So just kind of, I suppose, kind of a not scaremongering, but very much putting on your radar how important cybersecurity is at the moment. So if you haven't already, make sure your IT team are already, handling it. They should be all over it, hopefully. But just to flag a couple of really useful things. The first is that the Information Commissioner's Office published some ransomware guidance, either last week or the week before. Really practical, helpful guidance on how the ICO are interpreting certain things. One key point from that guidance is around data breaches, which is sometimes we think of data breaches just in terms of losing data or being hacked and the hacker getting access to the data. Loss of availability of data or loss of timely access to data is also would also be a data breach. So just to flag that data breaches aren't just about losing data, they can also be about losing access, which a ransomware attack would involve. The National Cybersecurity Centre have loads of really, really helpful guidance on their website. And I imagine your IT teams are all over that already, but just to kind of put that on your radar. And then the UK GDPR in terms of its requirements. So you have to have appropriate technical and organisational measures in place to keep information secure. But in addition to having those measures, the UK GDPR is quite prescriptive that you need to be also testing, evaluating and assessing those measures to make sure they're actually working. There's no point putting something in place and just assuming it's working. You need to be testing those things. So again, lots to think about there. Really want to put kind of cybersecurity very much on the top of your to-do list at the moment around data protection compliance. And then the thing I wanted to talk about is accountability, mostly because the Information Commissioner's Office are so hot on accountability. So if something does go wrong, you do have a data breach or somebody complains about your organisation's data protection procedures, practices, what you've done with their data, etc. And we are finding, just on a bit of a tangent, we are finding people are very much making complaints about data protection quite frequently at the moment. It's almost becoming kind of a routine thing that in the context of an employment dispute or a customer complaint, data protection very much being brought into these things. But if someone does go to the ICO and the ICO do look at it in detail, having this accountability requirement covered off already is going to put you in a really good position because you'll be able to show the ICO how you are complying because you've got all that documentation and records in place already. Just a few things to flag in particular. Staff policies are really important, both in preventing things from going wrong in the beginning, but also if they do go wrong, being able to say to the ICO, look, we had all these great policies in place, staff members were trained, we had these procedures in place, that type of thing. Data protection impact assessments are a legal requirement and kind of part of accountability if you're going to be doing anything with personal data that's likely to lead to high risks. And then just a flag as well that if you are relying on consent as your lawful basis, and it's only one of 6, so you might not be relying on it very frequently, but if you are relying on consent, really important to keep records of those consents. So what the individual was told, when they were told it, and kind of keep that record. So if the ICO do kind of come and look into your practices, you can actually demonstrate that the individual did give consent if that's the lawful basis you've chosen to rely on. And then just a final word on staff training. I am a huge fan of staff training. It's really a key measure that every organisation should have in place, good staff training. Because as I was saying a moment ago, data protection is not something that can be left to a few key individuals that have data protection in their job title. It really is for everybody in your organisation who has access to personal data to understand the basics. And often where Andrew and I get involved because things have gone a little bit wrong, it's because the individual in question maybe had done something that they genuinely didn't know they weren't supposed to do, or better staff training could have prevented something from going wrong, maybe a breach, for example. Also consider specialist training for certain groups. So very senior individuals in your organization might need to have more in-depth training. And then kind of a final kind of, I mean, we've got 10 minutes left and I'm keen to do the poll and some questions, but just a final point, make sure data protection is on the radar of your most senior colleagues. So kind of a board level thing, you know, data protection isn't something that can be delegated down entirely. Yes, by all means, have a data protection lead, have a team of data protection experts at your organization by all means, but it's something that the very senior level should also be aware of. And I know a number of organizations have data protection reports at board meetings, that kind of thing. So the senior individuals, your kind of board members, your executives, they are aware of what's going on the ground regarding data protection.